Welcome to Family Law War Room with Brad LaMorgese.
Welcome to Family Law War Room with Brad LaMorgese. Brad is a board-certified family law attorney in Texas who specializes in high-stakes divorce, complex property division, jurisdiction disputes, and family law appeals. I'm Shameika Rhymes, and today we're talking about what makes high net worth divorce cases different and how strategy changes when substantial assets are involved. Welcome, Brad.
Hi, how are you?
Doing well. How are you?
Excellent.
Well, what distinguishes a high net worth divorce from a more typical family law case?
A more typical case is going to have a house, maybe some retirement, bank accounts, those sort of things, which is pretty easy in the end to value and for a court to divide. A high net worth is not just a dollar amount because you can literally have a high dollar amount, but fairly easy to determine if it's in a brokerage account, for instance. High net worth to me is complexity. And high net worth cases involve layered assets. So maybe even one entity owning multiple other entities. Of course, you're seeing business interests. Typically, you might also see trust interests. In Texas, you'll have oil and gas interests, royalties, holdover payments, sophisticated compensation structures. So those can be executive compensation. We also see athlete compensation, which can get very complex because of guaranteed contracts. And then long-term financial planning issues that don't typically exist in many cases.
So what if someone had a prenup, would that be a high net worth divorce, or kind of it could go either way?
Well, the idea of a prenup should simplify the whole thing. Now, There can be complexity in prenups. There can be clauses in prenups that need to be interpreted, but a prenup can certainly minimize litigation in a high net worth divorce.
Okay. Well, what factors affect how the marital estate is identified in cases involving businesses, investments, or layered ownership structures?
Ownership doesn't always tell the full story. Assets might be held through LLCs, partnerships, trusts, or multiple entities. Income may be reinvested in those entities rather than distributed. So what you're really looking at is what is the top layer of what the parties actually own. And they really don't even own the underlying assets of a business. Typically, they own their interest in the business. Now, the assets are key to valuing it, but identifying the marital estate requires peeling back layers of entities, trusts, understanding cash flow, how value is created during the marriage, and it's less about labels, more about substance.
And I assume they need to be very open and honest about some of those things that they may own or have an interest in, right?
Well, for sure, that's required. Typically, in the first 60 days of the case or thereabouts. Now, it could be longer if the case is bigger, but you're going to be filing a sworn inventory and appraisement of all the assets and debts, and that will include trusts, business interests, whether somebody thinks they have separate property or whether it's community, and then valuing those entities or assets. Sometimes that will take a little longer because the professionals are going to be valuing those assets.
Where do financial experts and valuation professionals typically fit into the high net worth divorce litigation?
Experts are central to those cases. I would say pretty much you'll see an expert on each side, if not more than one, in those sort of cases. Business valuation requires professionals to sort through documents. Those will typically be forensic accountants. But valuation, you may even see, is different from someone who traces community property through a separate property asset. In those cases, the tracing experts often shape the case as much as the lawyers, including the valuation experts, to help identify assets, determine value, and explain complex financial structures to courts. you'll see expert work being almost the case. We obviously work very closely and hand in hand with these experts on what the law is, strategic judgment decisions on what is going to be separate or community. So the experts are critical in those kind of cases.
Well, what makes separate versus community property determinations more complex in high asset cases?
High asset cases almost always involve a lot of movement of assets. Entrepreneurs are typically very good at turning money and into more money. And so you're looking at commingling, potentially reinvestment, hopefully appreciation over time. And separate property may have grown dramatically during the marriage. It may have mutated into different forms. Those not only raise an issue of proving your separate property, but then also potentially reimbursement and character issues for the other side claiming, these things were lost to community. Tracing becomes more technical and the burden of proof matters. As you sit on day one, each piece of property in a divorce in Texas is presumed community, and the burden is clear and convincing evidence to prove it's separate. So that's even more than your sort of preponderance of evidence standard. It typically means documents, and it typically means some persuasion that the separate property is still preserved. These disputes are often very evidence heavy, legally nuanced, and it's particularly important to make sure that the records are admissible.
How do liquidity considerations influence the division of substantial assets?
Not all wealth is liquid. So businesses, real estate, and even long-term investments can't always be divided cleanly. Certain executive compensation, or obviously an athlete contract, that wealth is not transferable. And a lot of those assets can't even be divided per the terms of the contract. So courts and counsel have to consider tax consequences between assets. A cash asset is different from a retirement asset. We should consider cash flow and then feasibility. And by that, I mean, is one spouse capable of running the business? Were they a spouse who didn't participate in those kind of decisions? And so liquidity is going to be very important. A paper equal division can be practically unworkable if liquidity isn't addressed. Many times in those cases, we will arrange a liquid buyout within a certain time period that is secured by other assets that can be collected on. But liquidity is always a huge issue.
Well, what differences tend to appear in discovery when financial records span multiple entities or privately held businesses?
In those cases, discovery is deeper and broader. So by that, I mean, you're asking for a whole lot of more categories of documents. The length of your request is by nature going to be longer. For instance, in a separate property case, you're literally going to try to get every statement or every piece of paper all the way back to when an asset was inherited maybe, or from before marriage. In a business valuation case, typically the experts are wanting 5 years worth of a lot of records to go consider how to value that asset. They're typically looking at an income approach, which requires balance sheets, profit and loss statements, but they're also looking at asset approach, and then also other approaches where they're looking at the market potentially. So there's a need for targeted discovery, expert-driven requests, and careful sequencing. Protective orders and confidentiality in these cases also play a large role, because if you're dividing something for a celebrity, or if you're dividing an important company interest, that's not something that you want to go out in public.
What issues arise when compensation includes bonuses, deferred income, stock options, or partnership interests?
In those cases, timing and characterization are key. Is compensation earned during marriage and paid later? Is it contingent? And is it tied to future performance? The family code has a specific formula of how to divide retirement benefits. And it looks at the portion earned before marriage, during marriage, and after marriage, and is divided at the date of divorce to preserve separate property, but also to preserve community. Stock options literally have a similar family code formula that's built in. But other issues, for instance, one example would be an athlete compensation. Those have been litigated on appeal as to, is a guaranteed contract, if it actually still requires future performance, that future performance part can be separate property. So each structure raises different legal and valuation questions, and the answers obviously materially affect the outcome, but you're looking at the exact facts of each case and lasering in on them.
So this is just a random question. If we're still talking about an athlete and, with the stuff built into the contracts, if that athlete gets hurt, then what? And can't play?
That's a very good question. So if their injury compensation is tied to the contract and it's automatically paid, most likely most of that will be community property.
Okay.
If you can segregate out a portion of that compensation that would be paid post-divorce, for instance, there's a good argument there that it's separate property. Really, you're looking back at the contract, looking at the guarantee, and if they're losing money or losing a part of the contract because they can't perform, then we know that probably was separate property as well if they eventually can perform again.
Oh, okay. Thank you for explaining that. Well, how does the presence of business interest or long-term investments affect strategic decision making?
Strategy always focuses on preserving value, typically rather than liquidating it. That may mean offsetting assets, structuring payments, like I was mentioning earlier, or creative settlement solutions. Typically, litigation strategy also accounts for operational risk because harming a key business will result in harming both sides. So I think both spouses, even in the emotion of it, hopefully can see that the ongoing business is a better operational for both of them, rather than liquidating. Liquidating in a divorce is really a distressed sale. And if you have lack of control or lack of marketability of that asset, it can make it even more challenging. And so again, figuring out where is the liquidity, can that be awarded to one spouse versus the other, though both spouses typically have a need for liquidity. But then also, how can we secure a payout if an asset is pumping out a bunch of money in the future? How can that division be secured? And so business interests will complicate it, particularly if both spouses are not the owners or operators. And it actually can complicate it even more if they're both operating the business, because they may end up in competition against each other post-divorce. And usually both of them will want that business if they can see it's an income-producing asset.
Well, what goes into building a strategy that protects value while still moving a high net worth divorce towards a resolution?
This requires a lot of coordination. So legal strategy, expert analysis, and client objectives are all aligned. And the particular goal is typically to protect value, manage risk, determine characterization issues, whether something's community or separate, those are key, and resolve the case efficiently where possible. Strategy almost every time is going to involve getting ahead of your case early, not skipping steps, but prepping it with the inventories we discussed, prepping it with making sure the legal team, the accountants, understand all the documents, and really getting the client to work with the lawyer on that or be very responsive Or typically, a lot of clients will have a team that manages those to understand the importance of moving quickly. Typically, the quicker you move in a case to get ahead of the knowledge, the strategy, the stronger position you are to settle that case or to go to trial, and providing leverage as well to determining how are we going to try this case? What is the story that's pushed in this case? And understanding all the assets to have a strong legal position with the experts. The best outcomes, in my experience, come from thoughtful planning and not reactive litigation. And it may seem a little counterintuitive and it may be painful at the time, but assembling the case, all the documents needed for a complex asset litigation are critical. And then that's when you're in a strong position to try or settle the case. When it's cloudier, when the other side doesn't understand you haven't proved your separate property yet, or we don't really understand the value of the case, then it's going to drag out and everybody's going to be feeling like there's bad settlement offers going back and forth, even though it feels hopeful to get a case done for an efficient resolution. The typical best resolutions will be getting the case under our belts quickly and then pushing for the outcome.
Brad, this has been such an interesting and informative chat today. Thank you for breaking this down for us.
Thank you.
Well, that's it for today's episode of Family Law War Room with Brad LaMorgese. To learn more about Brad and his work in complex family law matters, visit lamorgesefamilylaw.com. Thanks for listening, and don't forget to subscribe, share, and leave a review.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.